Greetings, everyone. This is Professor McKenzie. Today we're going to be looking at Chapter 12, which involves legality. Remember, we're looking at all the different aspects and elements of an enforceable agreement. So we've talked about offer and acceptance. Sometimes that's called mutual assent. The last chapter we talked about consideration, which that consideration has to be flowing in both directions in order for there to be a binding enforceable agreement. This chapter, we're focusing in on that element of legality. And so, before you probably even read this chapter, you certainly know that if a contract is illegal, that's not going to be enforceable. But then there are different issues that can arise where maybe part of the agreement is legal, but then it might incorporate some elements of illegality. And we'll discuss what happens in that particular instance. But anyway, the overall learning objectives for this chapter, I want us to understand the types of contracts or bargains that are deemed illegal per se, and the effect that has, how courts deal with disputes when there are allegations of illegality that arise in an agreement, and under what circumstances will courts generally enforce otherwise agreements that do contain some element of illegality. So an interesting area in terms of what courts are willing to do or not do when the topic of illegality arises in an agreement. So as just a general principle, if the focus of any agreement is to commit something, an act, or provide some kind of service or good or whatever that is deemed illegal, then there's going to be usually no court that's going to enforce that aspect of an agreement. So if you're trying to contract with someone, so you will have them commit a tort, which we know is a personal harm on someone or their property. So that's an illegal act. That's not going to be enforceable, at least not in a court of law. If we're talking about something that is contrary to public policy, like illegal gambling, we'll talk about agreements that involve unconscionability. There's procedural and substantive. For right now, if something is both procedural and substantively unconscionable, then that's going to be deemed unenforceable. We'll get into more detail in that in just a few minutes. And so, I've mentioned this in the past, if, the legal theory versus the reality. So the legal theory, if you want to hire someone to do anything that's illegal, if the agreement, maybe a dispute arises, you're not going to go to court with that because you know that no court's going to enforce an illegal agreement. So that's the theory. The reality, obviously, on streets, maybe, if it's a drug deal or if you're hiring someone to hurt someone else, there are other mechanisms in place besides the court system to ensure performance of an agreement of this nature. And so obviously that's out of the purview for our discussion. But in terms of what is expected in a court of law, a court of law is not going to even entertain, enforcing situations such as these because of the element of illegality that lies at the heart of these agreements. As just a general principle for any contract, there's that element of good faith and fairness, which we've discussed. So, the fact that you enter into a contract, you don't do that if you're trying to, maybe hurt the other party in some way, financial or otherwise. That's not the premise that we kind of approach when you sign, whatever the agreement is, or, you perform, on the agreement. When we talk about elements of unconscionability, so we're talking about, whether, something is grossly unfair or not in a contract. There are two aspects of unconscionability. The first aspect of unconscionability is procedural, and then the second aspect is substantive. And so let me go through the procedural first. Procedural goes to a lack of bargaining power. If you're alleging that, sure, I entered into this contract with this other party, but I didn't have any real ability to negotiate terms. As long as those terms are not illegal, then the fact that you didn't have a chance or opportunity to negotiate, that does not undermine the fact that that is an enforceable agreement. So I like to give examples as part to try and understand these complex topics. So let's say you're Wells Fargo, and let's say they're a department that administers credit cards. Let's say that they decide they're going to mail out, 100,000 offers to various account holders in different states, an offer if they want to get a credit card, Visa, MasterCard, whatever. And so, let's say you and I get this offer in the mail from Wells Fargo. So, you open it up, which you all have, and so you read it, and there's no ability to negotiate. So they're going to say, you've been pre-approved if that's what the letter says. Maybe you're pre-approved up to a certain amount, maybe a $10,000 credit limit on this credit card, and this is the interest rate. Maybe there's an introductory rate, but then at some point the regular or the rate that normally would be in effect, that will kick in after 6 months, year, whatever. And we know that you either like the offer, and if you want it, fill it out, whatever the information they request, name, address, social, income, all that stuff, and you mail it in, and then assuming that everything's pre-approved, in a few weeks you get the card, you start using it, we're happy consumers. That's it. If let's say down the road you fall into tough financial times and you can't pay the credit card. And so, they're coming after you, Wells Fargo, for non-payment, and you decide, well, I'm going to, my defense, if we end up in court, is going to be that, well, I couldn't negotiate the terms of this agreement, that's not a defense, for failure to pay an obligation. So, just the fact that something is procedurally unconscionable, we're not going to say that that's not going to be enforceable. You have to also allege that there's some substantive aspect of the agreement that's unconscionable, which I'll get to in just a minute. The reason why we allow for procedural unconscionability is that for contracts, you don't have to enter into them. So if it's that credit card offer from Wells Fargo, you and I don't have to accept it. We could just shred that document, throw it away. If we required banks to negotiate, for in this example, like every credit card offer with every customer, you would see a lot less credit cards being offered at that point because it's too cost prohibitive. So, and imagine if, Wells Fargo mailed out 100,000 responses, and let's say everybody kind of wrote in, well, I don't want, 19.9% interest. I want 0% interest for the life of this card. So they start writing stuff in, and then they sign it and send it in. That's not going to work either. So, we want to give businesses, and in this case, like Wells Fargo, some flexibility when they're making blanket offers to different customers. So the fact that you could not negotiate does not undermine the fact that that is a binding agreement. Now, if, procedural is coupled with substantive, which usually it is. I'm hard pressed to think of some examples where something is just procedurally unconscionable and not substantive, or vice versa. So that would be kind of a hard example to think of. But if you do incorporate both of those, then in that situation, as a defense, you could say, as part of your, what you would allege in court, is that because you have this aspect of procedural and substantive, that both are deemed unconscionable, that you want to be excused and avoid liability under this agreement. So maybe, not to pick on Wells Fargo, but let's say, what they offered was an interest rate that was in excess of what is permitted under state and federal law. So it's usury, so, well, okay, procedurally couldn't negotiate. Substantively, they're charging you 50% interest, let's say, that's not legal. So that would be the basis for your defense to say, well, I want to be excused from performance on this contract. So, again, you kind of see what's happening with this dynamic. When we're talking about unconscionability, if it's just procedural, you're going to be stuck with that if you signed and agreed to it, even though you couldn't negotiate. If it's procedural and substantively unconscionable, now we have a case to try and have you get out of that agreement. Usury, as I mentioned, that's when, if you're a lender and you're charging a higher rate of interest than what is permitted under the law. What I've kind of seen in modern kind of like commercial transactions is kind of like a massaging of language by lenders to avoid the appearance of interest, and, varying states and varying courts have struggled with trying to nail down a precise definition. At its very most broad definition, if you're being advanced money and you have to pay some kind of fee to get access to that money, I think you could make a claim that that is interest. If you go to these payday places, obviously they don't say they charge interest, but what they will say is that they are charging maybe a handling fee or a service fee or something in order for you to get some kind of like advance, $500 or whatever, like a payday loan or something. And so, again, some states and some courts have ruled that, well, we're not going to say that that's interest, even though, you wouldn't be able to get those funds unless you paid those fees. So this is an area where I think there is a legitimate concern from a consumer protection area, because sometimes if you factor in, the fact that, maybe some debtors are rolling over these debt obligations continuously because they're always short of money. Now you're looking at where you are having an interest rate that is, 50, 100, 200% if you annualize it. So it's something to consider, if you are at all concerned about consumer rights. So usury laws around the U.S. fluctuate greatly. Florida, for example, if we're talking about personal loans, there is an 18% cap on interest if interest is stated in the loan documentation for up to $500,000. If you're loaning someone personal loan that's over $500,000, then the cap is 25%. There's no limit in Maine, Nevada, New Hampshire, New Mexico, South Carolina, and Utah. Washington, North Carolina, and North Dakota link it to like the rates of T-bills or Treasury bills. So there's that gives you at least a benchmark that you can kind of refer to. But again, the idea of what is usury, there's a lot of variability around the country, as you can see with these examples. Any agreement that is in violation or negatively impacting public welfare, that can be deemed to be, illegal from an enforcement perspective. So some examples that are agreements that affect public welfare, that could include agreements to maybe like buy a government job, it could be considered like a bribe. Providing compensation for sexual services. There are some limited areas in Nevada where that is legal, but for the most part, it's illegal across the United States. Illegal discrimination contracts, wagers, lotteries, agreements to obstruct the legal process. So whether they're in writing or verbal doesn't matter. These are all examples where, for the most part, courts are not going to entertain their enforceability because of the illegal nature. When we talk about agreements not to compete, and so the author discusses this briefly in this chapter, if any of you have ever signed a non-compete agreement, or if in the future you sign one, there are some things that I want to make sure we're clear on. Employers, when they hire someone, they bring someone into the fold. They're going to train you. They're going to give you knowledge, skills, expertise. You're probably going to become a better professional over time because of the services that you provide that particular business. And what they really want to avoid happening is, workers, gaining all this experience, maybe getting to know customers or contacts, and then going to some other business or maybe starting their own business, and then now they're a competitor. So there is a legitimate concern, by business owners, and I get that. The other concern is if you're selling your business. So if I'm good, let's say you're selling the business and I'm going to buy it from you. The last thing I want is to give you a bag of money for your business and then you leave. And so I start, I run your business, which now is my business. And I find out, a week later, you've opened up down the street and everybody knows you. And so now it's like I have no business because you're now my competitor. So an agreement not to compete can be brought up usually in one of two ways. It can either involve, the employment contract, whether that's verbal or in writing, I don't want you to compete in the future, or it could involve the sale of a business. And so that would be just a provision in the sales contract. Anyway, when we talk about non-compete agreements, there's usually two dimensions that we're focusing in on, geographic scope and then the time or the duration aspect of what is being asked or expected of in the agreement. So again, I always like to go through examples. So usually geographic scope is what gives students the most problem to try and wrap their mind around, because that is very fluid. It's very flexible depending on the position. Time, usually if we're looking at a duration of 2 or 3 years or less, that usually is considered reasonable. So you know, and let me give you a couple examples. So let's say I teach off of at the West Campus off of Kirkman, and so let's say on Kirkman Road there's a hair salon, and so you can be a barber shop or a beauty salon, you know, whatever, you know, you want a cosmetologist, I guess, whatever the label is. And a lot of times they are expected to sign agreements not to compete because there's some fluidity there. You know, they come and go from different businesses, different salons, different barbershops. So if the owner of the salon, you know, says, okay, I'll hire you, but I need you to sign this agreement not to compete when in fact you do leave at some point, that's fine so far. And so let's say the agreement says that you're not going to compete for a period of 2 years. So that's fine, the duration. And the geographic scope is within a 3-mile radius. You know, salons and barbershops are usually neighborhood based, and so that duration and geographic scope are reasonable. You know, it's like, well, okay. And what that means is if you want to leave at some point that business, and let's say you want to work at a salon that's, you know, within that 3-mile bubble, you would have to wait 2 years. And then you could work, you know, in that bubble, and there's no issue. You know, if you don't want to wait 2 years, then just go outside that 3-mile bubble, and you're fine at that point. You know, we're not saying that you're banned from working on the entire planet. That's no way that's enforceable. So you see how these agreements not to compete act. Now, change the facts a little bit. Let's say that same salon, you know, they say, okay, for 2-year period, but instead of like a 2 or 3 mile bubble, let's say that they say a 50-mile bubble. You know, that would be too excessive. There's no judge that would enforce that. You know, so, you know, if you look at 50 miles from Kirkman Road, if you go east, I think 50 miles would take you into the Atlantic Ocean. If you go west, you're probably getting close to Tampa or St. Pete. If you go north from Kirkman, you're probably looking at what? Maybe getting close to Ocala, possibly. South, whatever is south, you know, of here, 50 miles. So that's too excessive for what's expected. And so that's where, you know, a judge can either just throw it out and say it's not enforceable, or the judge could scale back that bubble, which is too excessive, and say 50 miles is too much in this case, but maybe 2 or 3 miles is reasonable. So you can always modify and fix an agreement. You know, let's say you're talking about a different job, though. You know, maybe you are a salesperson for Coca-Cola, and let's say your territory is all of Orange County. So we're talking about, you know, what, 1,000 square miles or more. And so, you know, if your non-compete agreement says, you know, we don't want you to compete against us, like if you go to Pepsi or RC Cola, we don't want you to compete with us for 2 years, that's okay. And if they say, and not within Orange County, even though we're talking about a huge area, you know, in terms of square miles, if that's what you normally did, that would be acceptable then. So if you wanted to go work for Pepsi, you'd have to work for Pepsi in Seminole County, Volusia County, Brevard, you know, Osceola, you know, wherever, Lake County, wherever, but not Orange County for that 2-year window. So backdrop of all of that, there are states that do not recognize non-compete agreements. So I have here on this list, you see Washington, California, Montana, North Dakota, Minnesota, Oklahoma, West Virginia, so on. So in those particular states, you know, even if you had signed one in the state where it was legal, if you relocate or transfer to a state that's on this list, that employer cannot enforce that against you at all then. Let's say, I'm not aware of Walgreens doing this, but just as an example, let's say if you're a manager at Walgreens, they make you sign a non-compete agreement. And, you know, let's say that, you know, you became a manager here in Orlando, Florida, and then for whatever reason, they transfer you to, you know, let's say Spokane, Washington. So you get to Spokane, Washington, and you're there for, I don't know, 6 months, and CVS or some other, drugstore offers you even more money to come over and be a manager for them. And you quit and you work right across the street. Walgreens can't pull out your Florida non-compete agreement and say, we're going to enforce this on you here in Washington state, because in Washington, they're not enforceable. So again, just kind of understand the dynamic of what's happening here. Businesses a lot of times, and again, I'm not faulting businesses because they have a challenge, just trying to, earn a profit. They have a lot of things that they're dealing with. But sometimes they'll present you with legal documentation, and they'll present it as, well, this is the standard that's going to be enforceable in any court of law, so don't even think about violating this. And the reality is that that's not true. It's up to a judge to decide if something is enforceable or not. It's not up for your business or your supervisor to make that determination. They can say, we think this is enforceable, but ultimately a judge makes that call, not them. So a couple of situations where we're looking at different facets of agreements not to compete. So in Precision Walls, the court held that a 1-year restriction was reasonable. And if you were trying to prevent someone from working in 2 states, again, you have to kind of go to the underlying, was that their normal territory where they worked? If so, then that's going to be considered reasonable. Same thing with Forrest Pashal Machinery, a 350-mile restriction was deemed reasonable because, again, it related back to what their original job responsibility was. Hartman, in that case, a 10-year restriction was patently unreasonable. There's no industry that would justify imposing on a client or someone who's selling their business that you can't compete for 10 years within some bubble. That's just unrealistic. That's not going to be enforceable. One other quick slide with some examples. Lloyd versus Southern Elevator. The court enforced the non-compete agreement here, restricting a former employee from competing in any county where they had worked for 2 years and in any location within the boundary of those counties within 100 miles. So again, that's a situation that arises. This happened actually to a friend of mine. I don't have this on the slide, but several years ago, a friend of mine, his spouse was a nurse practitioner, and they were working for one of these chain kind of like medical clinic places. And they had an agreement not to compete, which is common. And in the agreement, it said that, this person, if and when they leave, they cannot compete within it was like a 2-mile radius of any of their locations in Central Florida. And the thing that you have to be careful with there is, well, what is their coverage, their map coverage? Because it's almost like in the agreement they were creating like islands around Central Florida where my friend's spouse would not be able to work within a 2-mile radius of each of these little like locations. And depending on the business, if you have a sufficient number of locations, you could see where boundaries could start to overlap, and now you're kind of forcing yourself to keep looking further and further out of the territory in order to secure some kind of future employable position. So you have to be really careful in terms of how things are being worded in these non-compete agreements. And again, if you think that there's some unreasonableness to this, that's why we have courts. Courts can challenge and the veracity of whatever is trying to be asserted in an agreement. This is just one example I'm going to discuss, and then I'll be finished with this chapter today. So this is a great case. It's an actual case. Sidel purchased some fireworks from Red Devil Fireworks. It's a manufacturer and distributor of fireworks. And the sale was illegal, however, because Sidel did not have a license to make the purchase, which Red Devil knew. So fireworks across the United States is heavily regulated as an industry because of safety concerns. And so if you're going to sell fireworks, you have to have a license that's issued by the state. And you have to go through the Secretary of State for every state that you want to sell fireworks in. And it's easy if you're a seller like Red Devil, the manufacturer. All you have to do is call the Secretary of State, or you can even look online, and you can see who has a license or who doesn't to sell. And so if someone approaches you and they try and submit a purchase order, it's your obligation to cross-reference to make sure they are licensed. If they are not licensed, then you are not legally permitted to sell them inventory. Anyway, Red Devil, they checked out the background of Seidel, and they realized that he was not authorized, but they went ahead and sold him the inventory anyway. And so they billed him, like a month later, an invoice saying, okay, this is what you owe based on the order we shipped you. He didn't pay. And so Red Devil sues. And, we've talked about, if you recall in previous chapters, this idea of unjust enrichment. We do not normally want someone to benefit at the expense of someone else because that's unfair. This, however, is a situation where, Red Devil, they made a critical mistake in knowing that Seidel was not licensed, and yet they still sold to him. So the court just basically treated this entire agreement as being illegal. And because it's illegal, it's not enforceable. So Seidel was able to get inventory, sell it, and keep all of the proceeds and not pay for any of the inventory. Normally, we don't like that. But here, the court wanted to send a message to Red Devil and any company in this industry or similar industries that if you willingly know that someone is not licensed to handle or and sell things, that are protected like this, and you go ahead and sell to them, if that agreement goes bad, then you're going to have to eat those costs. And that's what Red Devil had to do in this case. So it was definitely a lesson learned that, any future purchaser that they're going to sell to, they're going to make sure that they are properly licensed. And if they're not going to sell them any inventory. So I hope you have a greater appreciation for the topic of illegality and how that impacts modern contracts. If you have any questions like normal, please let me know, but have a wonderful rest of your day. And I thank you.